they can do it, I really think they'll overcome it there. Yeah.
Well aware.
Yeah.
Mr. Suba, we're ready for your case. You want to come up to the defense table? How you doing today?
I'm doing fine.
I think the first thing we should do is firm up which of Mr. Suber's pretrial filings we're going to consider today. Maybe we should consider all of them. Let's at least get looking through the file quickly. I've found three sets of December 15th, 2021. That's called First Amendment Petition for Common Law Abatement Notice Affidavit. And then on July 15th of this year, there was a filing entitled Legal Notice, Name Declaration, Correction, Proclamation, and Publication. And then on September 13th, 2022, which was a couple of weeks ago, a document was filed. It's 2 pages, Mr. Suba, really without a title to it. But you, presumably you and an orange highlighter highlighted Rule 2.6, which says ensuring the right to be heard. The judge shall accord to every person or entity who has a legal interest in a proceeding or that person or entity's lawyer the right to be heard according to law. I certainly agree with that. So, what's your understanding, Mr. Suber? What are you interested in presenting to the court today?
I'm just interested in here to correct the mistake that was made for the name Mr. Suber.
Okay, let's just get the list of things. And then we'll go back to address them each one. What are there other issues that you'd like to bring to the court's attention today?
Yeah, because I keep on being called the defendant when I'm the beneficiary of the name. The name Suber Ronald Jr. I'm just here to correct the mistake. I'll accept the charges for discharge.
Okay, well, why don't you make your, anything else? Again, I'm trying to list here. I've got 1, 2, the correction of the name Mr. Suber, number 2.
And
correction of the reference to the defendant. What else?
And I'll accept the charges for discharge. Me being the beneficiary and this court being the trustee for the charges.
Okay, well, I've got 3 things then. Why don't you present your your argument to the court, you have documents to present. If it's proper, we can make it part of the record. What presentation would you like to make?
The first one is a special visitation that it has to be, I want a trial by jury, there has to be a witness and a victim for these charges, for this matter to proceed.
Well, there'll be a witness.
Okay, and
The Commonwealth can't present anything to either a judge or a jury without a witness.
okay, and the victim for it to be a crime.
Mr. Judge, what is the Commonwealth's position as to the status of the victim in this case?
Your Honor, the victim is society, but by the nature of the
Well,
breaking of laws.
can society step forward and say how I injured them?
Just a minute.
The legislator has deemed certain offenses within the Commonwealth of Pennsylvania to be crucial to the peace and balance of the community, and certain conduct that breaks that peace is a violation of the law, and any violation of the law which breaches the peace in this nature, society would be the victim.
That
Judge, to the extent that an arrest was resisted and there was an individual who was subjected to that resistance, those officers will be present as both the witnesses and I think
Trensley versus Pegliero, it cannot be you can't be a lawyer or you can't be a witness to a crime.
Well, why don't you let Mr. Judge finish first?
So those individuals, Judge, who were subjected to the obstruction of law enforcement and the resisting arrest will be present to appear on behalf of the Commonwealth and represent their involvement, how their jobs were obstructed, and I think that they will stand in the shoes and represent society as the victims.
Okay.
That can't happen because it has to be an injured party for it to be a victim. How did I injure them officers? And obstruction is me not identifying myself as Mr. Super, which I don't have to, according to the law. Colander versus Lawson, I do not have to identify myself unless there is that's my main point. It has to be a witness and it has to be a victim, somebody physically here to say that I injured them and how I injured them. And a trial by jury. These are just facts. I mean,
Look, you're not exactly, I'm not going to engage in a lot of back and
no, it's not a back and forth. I only just state facts.
Well, I'm not going to engage in a lot of back and forth with you. But there are certain crimes that don't have a victim.
No, that's the law. It has to be a victim for it to be a crime.
There's no victim in a
And there's no crime and
instance.
there's no case.
Well, for example, and look, believe me, I don't intend to change your mind.
No, I know.
I'm just saying, I'm just stating the law. There are certain crimes that don't have, there are certain crimes that have victims. If there's a dead body on the floor and there's a bullet through the skull, that person is a victim.
Correct, that's a murder. These are not crimes.
Hold on a second. A victim of murder or some degree of homicide, most likely. A driving under the influence charge where somebody gets pulled over because they've been weaving within their lanes. They do the breath test and the field tests. For that type of, now if they cross the center line, and hit another car head on, then there is a victim. But a lot of DUI cases, just by way of example, don't have a victim that can be stood up by the Commonwealth and put on the witness stand. The police officer making the arrest really isn't the victim. I guess back to Mr. Judge's comment a moment ago, in a certain sense, society is the victim, or those others on the roadway that could have potentially been harmed, but weren't harmed by a drunken driver. So you're incorrect, and I'm not going to do a lot of back and forth here, but you're incorrect that there must be a victim in every criminal case. A live, warm-blooded victim standing on two legs, that's not accurate.
It has to be a corpus delicti for it to be a crime. That's just a fact.
That's a different issue.
How is it a different issue? A crime is a crime, correct? It has to be a victim.
What do you think corpus delicti means?
A victim to a crime.
What else do you have?
That's it. And to correct the name, because you keep on calling me Mr. Suber and the defendant when I'm the beneficiary of the name.
What I need to do, you're free to call yourself whatever the heck you want, out of the confines of this courtroom. But within
And I
the
have
criminal
legal-
justice system, you're not entitled to be called what you want to be called.
Says it right here. Rule 1, you just read it yourself. 2.6 actually.
No.
My abatement says that as well.
Anything else?
Matter of I'd like a motion to change venues because you're being very biased right now.
I mean, what?
Biased. I would like to change venues.
I'll tell you what, Mr. Super, I don't compare myself to other judges because I very seldom get in other judges' courtrooms. Maybe never. And I'm not tooting my own horn here. You'd be hard pressed to find another Chester County judge who would be as patient or fair with you as I am being.
But you're not
I don't
following
say that-
procedures.
I don't say that, pat myself on the back.
I respect
say
it.
that because I think you check around.
No, but I respect it.
You
But you're
check-
not following your
you
own.
talk
You're not even
around,
following Pennsylvania
you
civil
see-
procedures.
And you see who you think you're going to get a fairer, more patient treatment.
Pennsylvania
from.
231 2002 says I can come in as a party of interest.
You're not. You're.
Yeah, no, I'm not a defendant. I'm the beneficiary of the name Ronald Suber.
All right, back to that.
And is this court the trustee? I'm pointing this court the trustee up to to handle this matter.
You can do whatever you want, but I'm not a trustee. I'm a judge. And
I
you're
said
not a
the court.
beneficiary, you're a defendant.
No, I'm the beneficiary 2002. You're not even following Pennsylvania rules. You're being very biased.
At this point in time, I will take the acceptance that Mr. Suber has put us on notice to call his matter trial, that he has demanded a jury trial. That is very clear. And at this point, I'm making a motion to dismiss the pending motions for failure to state a claim, which would be concurrent.
All right, I'll take it under advisement. I'm not going to make a decision now.
How is it taken in under advisement? You're trying to motion to dismiss it. These are all just facts. Ignorance of the law is no excuse, whether you know it or not, or have your own perception of the law, because you got some type of pecuniary interest in the matter, or do you? Is this a court of law or is this a business? Because the county of Chester says this is a private company, which is on the company website. You want to see?
I'm good, thank you.
Okay. This says it's a private company, so this is technically not a court of law.
I can
So
assure you that
I'm just here to handle the
County of
business.
Chester is not a private company.
It says it right here. You want to take a look? It's highlighted for you. It says this is a private company. This is on the company website. That's the number right there to this business. You dial 5, you get the clerk of courts. This is on your company website. This is a private company. I'm just here to handle the business. Nothing more, nothing less.
Anything else? I wasn't going to make a ruling on that.
No, I'm just here to handle the business. That's how I'm going to come every time I'm here. Because you're being very biased and I need a change of venue. That's it. Federal to be exact.
Excuse me?
Federal.
You want this case to go to federal court?
Because you're being...
What's that?
Change of venue. Put my motion in to change the venue.
You have that in writing?
Yes, I do.
I'll give that to the court clerk. They'll file it. I'll make a ruling on that.
You
too.
can have that. I got a copy.
So you want me to pass this off as a final?
Yeah.
Okay.
Should I'm passing up on campus, just so I reviewed it.
I'm debating in my mind whether to set up a hearing for the next miscellaneous session on this motion to change the venue. I'm not trying to prolong this.
Me neither.
I didn't suggest that you were.
Okay.
But on its face, that is a proper motion to be filed in the criminal case. I'm sure you know, or you may know, Mr. Suber, that what change of venue means is that this case would be moved to another county.
Oh, I know.
Change of venue doesn't ask for the removal of the judge assigned to the case. I'm not trying to encourage you to do anything, but that would be a motion for recusal. And a person who believes that the trial judge is handling the case improperly or shows bias or prejudice can file a motion to have that judge recuse himself or herself. The judge would, in the first instance, makes that decision, whether he or she thinks she ought to stay on the case or not. So the change of venue, what you're asking for is to have this case moved to, it can't be moved to the federal system, but it could be moved to Delaware County or Lancaster County. I'm not suggesting that I think it will be. But that's what a change of venue requests. Now, there are a series of criteria that would suggest that a change of venue in a criminal case be granted, the most typical of which is that a case has been of such high publicity, a spectacular murder case, where some high county official has been charged with a crime. And it's not possible to get a fair jury in the county where the criminal conduct allegedly occurred. Most of the ones I've handled over the last 14 and a half years have been in murder cases where the defense counsel believes that there's been a lot of newspaper articles, for example, and the jurors may have read the newspaper articles, and it's not likely to be possible to pick a fair jury, an unbiased jury, because of what they've already heard about the case. That may have prejudiced them. So just so you know what you're asking for in a motion for change of venue, you want a hearing? You want me to set a hearing or have the court administrator set a hearing for the October 17th miscellaneous week to pursue your request to have this case transferred to another county?
I'm just trying to get this case dismissed in general. Like I said before, I'll accept the charges for discharge for value.
Mr. Judge, does the Commonwealth intend to withdraw these charges?
No, Your Honor.
And you're not going to plead guilty, obviously. So
No, because that's an admission of guilt.
Yeah, right.
And I never signed no contract with this court or this company, I should say, because this is technically not a court of law. As
Okay. Again, you're certainly entitled to your beliefs on these.
no, I don't believe anything. I only just state facts. That's why I have everything in black and white that anybody can look up themselves.
But the Commonwealth is not going to withdraw the charges
Okay.
or null pros them, meaning that they would go away. You're not going to enter a guilty plea, and that leaves but one procedural alternative, and that is that we have a trial.
And there need to be a victim and a witness, as I stated.
Now,
There has to be somebody there to say that I injured them. These are just facts.
if you want to argue that to a jury, you can argue it to a jury.
It's not going to be no trial or no jury. He has to have a victim and a witness. That's just
There will
simple.
be witnesses, and I've tried to explain to you. Again, I said I didn't think I'd convince you, but there are certain crimes that don't have a victim per se, like a warm-blooded body who's a victim. Some crimes do. Some
That's
crimes
an
don't.
injured party.
Do you want me to set up a hearing for the week of October 17th on your request to have this case transferred to another county? I'll give you a
Yeah.
hearing on that. I don't think you're going to win, but I'll give you a hearing on it.
No, I don't need no hearing. I'm tired of coming back and forth, to be honest. Because you're failing to do your job as administrator.
Anything else today, Mr. Super?
No, I'm done. But like I said, there needs to be a victim and a witness to this trial. That's just simple.
I understand your position.
Well, if you did, you would stop calling me a defendant or Mr. Suber when I stated that's not who I am. I'm just here to correct the matter.
I didn't say I agree with you. I said I understand your position.
Okay.
Distinction. The case has been called trial, jury trial, and how soon can the Commonwealth get its witnesses
And victim,
together?
which is a fact.
You're going to lose that for the reasons I've been trying to get you to listen to. Go ahead, Mr. Judge.
Just for the record, we oppose the change of venue. Understanding the court's going to take that under advisement. Additionally, the case will be listed for the October 24th trial term, and we anticipate being prepared to proceed during that term.
Has that come out yet?
Yes, sir. This week.
The master list?
The master list came out this week.
So Mr. Super ought to be expecting to get a date certain for trial.
If the court will allow, I can open a computer and actually
Okay.
determine what date that is.
That's good.
Now, obviously, that'll be around the availability of jurors and the court and everything else that goes with that.
None of these charges on here are crimes, so that's what y'all think y'all can do what y'all want. I'll settle this now. So do you have the 1099 OID for this case, for these charges?
Judge, Mr. Suber is currently scheduled for a trial date of October 25th, 2022. Those notices arrived in my inbox yesterday, so they were moved in and out yesterday.
Okay, that's a Tuesday. At the moment, I still have a murder trial scheduled for that week, the week of October 24th. That's Commonwealth versus Ortiz and Encarnacion.
Mr. Suber's number 71 on your members list. That's number 1. So.
Okay. All right, I will pledge to both sides to have my ruling in writing. Issues advanced by what do you want to be called, Mr. Super? Not that I'm going to do it necessarily. But what do you
That's not even the point, because you're, like I said, you're being biased, so I'm going to see that you get recused from the case.
How can I be biased when they ask you what you would like me to call?
You just, I'm not, like you said, I'm not going in a back and forth match, so it's really no point. I'm just trying to, I'm here to accept the charges and have them discharged, that's it.
Okay, that's not going to happen.
Okay.
Thank you. Appreciate it. Thank you, everybody.
So who has a 1099 OID for this form? I mean, for these charges? Do I go to the clerk to handle the banking matter? Because I need this fill out. Do I go, or do I go to the solicitor? Who handles the banking matter for these charges?
This is that. You ain't gonna get no justice in there. Going back and forth with another thing.